Okay. Okay, I guess the issues were from my end. All right. Okay, so I'll just go ahead to introduce our speaker for today. So our speaker for today is Jumoke Fajimorokun, and she's going to be giving us an overview of the PIB. Mr. Adefulu is also going to come on to speak to us for a few minutes on an overview of the bill. So without wasting too much time, I believe Mr. Erojipe will come back at the end of the session to give his opening remarks, or by that time it will be closing remarks. Please, for anyone who has any questions, please put your questions in the Q&A box, and we will take questions after 1 hour of this session. All right, Jumoke, please, over to you.
Okay, good afternoon, everyone. It's a pleasure to be here. And first off, I'd like to thank the organizers for inviting me to be part of this 16-day training. It is an honor, and I'm really grateful. And so today, I'll be discussing an overview of the Petroleum Industry Bill 2020. And I'll try to make this interesting as possible. I'm looking forward to a stimulating discussion in the Q&A. So permit me to share my slides. Yeah. Okay, so here's an overview of the Petroleum Industry Bill 2020.
Hi, Jumoke. Okay, Jumoke is frozen. Okay, so while we're trying to get Jumoke's screen, just bear with us a second. Okay, Jumoke has internet issues on her end, so just give us a second to sort that out. Okay, Jumoke is back on now.
I'm sorry, right. I got disconnected there. So let me share my screen again.
Okay.
Just bear with me. For some reason, it's not showing as an option to share, so just bear with me.
Okay, Mr. Wally.
Hello.
Yeah, please, can you allow Jumoke share her screen? Has she been enabled?
It should be able to share the screen now. I think it's on.
Okay.
It's on.
Okay, so almost done.
Okay. Okay. So
okay, we're good to go.
Yeah, I'm good to go. And I hope my voice is loud enough.
Please make it as loud as possible for
okay.
answer saying it's
I'll
not.
try my best. Okay.
Okay.
So I'll go through, basically, I'll introduce the reasons why we've had to have reforms in the petroleum industry. And we'll take a journey through the PIB, basically the PIB journey through the years. As we all know, it's something that has been in discussion for since 2008. And we've been at it for quite a bit. So we'll just go through that process. I'll also discuss some of the current challenges and drivers for success, discuss the National Petroleum and Gas Policy. So this is just all to lay foundation for the PIB 2020. And as many of you would know, it's a very large document and it's very comprehensive. It covers various aspects of the industry. So, and it would require, typically it would require a lot of time to go through the entire thing. So I'm going to focus my discussions on the governance provisions and provisions on administration. This is a 2-day workshop. And so today we'll be focused on governance and tomorrow we'll talk about administration. Okay, so why do we need a petroleum industry bill? Why do we need to reform the petroleum industry? There are many reasons for this. And chief amongst this is that the legislation that governs the most important sector for our economy, our revenue earner, is about over 50 years old now. It's it's obsolete. It doesn't address current realities and current needs. It's focused on basically deriving revenue from crude oil exports and not really exploring the linkages and the value additions that we can have within the country. So there's no clear framework for the midstream and downstream sectors within what we have now. The regulatory framework is overlapping in some parts. You have institutions performing policy, regulatory, and also commercial roles all in one. Institutions are weak. The issues, because we have overlapping frameworks, we have vested interest, you have government in business, you have the same entity promoting policy and also driving regulation, that results in being weak in the way in which the regulations are applied. There are issues with transparency and accountability, and these are, things that we hear every day. And there's no clear framework to ensure that the industry actors are transparent and accountable. The regulatory framework is uncertain. There are instances where one is not clear about the rules that apply in specific circumstances, and you have to go to the regulator's office to ask questions about this sort of thing. So there's a lot of uncertainty. The host communities are not seeing the direct economic benefits of our petroleum wealth. Like I mentioned before, it's export-oriented, limited focus on value addition. Our infrastructure is limited. It doesn't support the domestic market sufficiently. There's lack of focus on the midstream segment, and also there are issues around funding of joint venture operations. These are joint ventures between NNPC, IOCs, and some independents. So that's the framework, and that's why a reform is necessary. So looking at the progression of the PIB, so this all started, it's been a 20-year journey, and for many people, many of us, we are hoping that this is not a journey that will continue to count, that will keep counting. So this journey started in 2000, the year 2000, when the Oil and Gas Reform Committee was inaugurated. And it was tasked with making recommendations for restructuring the petroleum industry. And this resulted in the issuance of a national oil and gas policy in 2007, which recommended institutional reforms that would ensure transparency and accountability. And following this, the first version of the Petroleum Industry Bill was then presented in 2008 to the National Assembly. This bill was a very large document. It sought to address everything in the petroleum industry and maybe other things that shouldn't have been addressed. It was very unwieldy, and it proposed very far-reaching reforms, and there was a lot of opposition to it. Various versions of the bill emerged in a bid to produce an acceptable draft. And at various points, one was not even sure what version was the official version. So eventually, this bill was withdrawn and represented again in 2012 under the Jonathan administration. So basically, a new draft was presented that sought to consolidate the different interests and was now, came into play in 2012. We were on this journey from 2012 to 2015, and it was eventually passed by, well, it was passed by the Senate, sorry, by the, I think by the Senate, yes, at the end of the 7th Assembly in 2015, pretty much on the last day of the 7th Assembly, and at which point nothing could be done to make the bill progress. So that died a natural death. And so the Buhari administration in 2015 now introduced the PIB again, but this time the decision was taken to separate it into 4 different bills. A bill covering governance, that's the Petroleum Industry Governance Bill, a bill to cover the administration of the sector, the Petroleum Industry Administration Bill, a bill to govern host community and how to translate the benefits of our petroleum wealth to host communities, and basically ensure a social license to operate, and also a bill that was to reform the fiscal regime for the oil and gas sector. So in 2018, so the PIG bill, that's the Petroleum Industry Governance Bill, was prioritized, and that moved, well, somewhat faster than we had seen in previous times, and it was eventually passed by the National Assembly in 2018. Unfortunately, the president declined accents, citing various concerns as regards funding and governance. So we're back to square one again. And in 2020, a new PIB was now presented, and that PIB has gone through the first and second readings. Public hearings were held in January 2021 of this year, just 2 months ago, and we're basically looking forward to seeing it passed in the very near future, touch wood. So what has been, what would you say has accounted for this journey that hasn't produced us with a new legislation? Part of it is lack of ownership. Initially, we had several drafts flying over the place, and there was no clear direction as to what was driving this reforms. And also issues around misalignment between the executive and the legislative arms. Of course, as one would expect, there was opposition to the fiscal terms and a lot of vested interests involved, because you're trying to shift the norm. And if you're trying to shift the norm, you have to deal with vested interests that would, rather have it shift their way or maintain the status quo. And also there were lots of disagreements around host community funding and how this should be treated going forward. And the impact on the sector of all of this has been reduced investment, because investors need regulatory certainty in order to have the assurance that their investments will result in returns. And because we've been in this state of reforms are coming, reforms are coming, reforms are coming, right? There's that investor confidence to put in money into the sector has significantly dwindled. I think I read somewhere that in the last 4 years, about $70 billion of investment came into the petroleum sector and in Africa. And out of that, only $3 billion came into Nigeria. So we see the real impact, and that has been very detrimental for us. So even now, in today's context, we have new challenges. There are new sources of oil and gas resources emerging around us. And so there's increased investment and competition for investment dollars. In addition to that, we now have issues around climate change and the energy transition. So demand for oil is projected to decline over time. And so there's the need to be more responsive to these realities. There are alternative energy sources emerging, new technologies emerging, cheaper technology. And in the global economy, there's a shift away from funding oil projects. It's no longer cool to fund oil. Everyone is going green now. And we also see the major IOCs decelerating from their oil investments and making major announcements as to their initiatives towards riding the energy transition. So it's important that the petroleum industry bill is responsive to all of these realities to ensure the sustainable development of the sector. And the key drivers for ensuring this are transparency and good governance, accountability, predictability, clarity of roles, being in line with global best practices, and promoting competitiveness, as well as ensuring that it promotes an environment where there's ease of doing business. So let's take a flashback to 2017, when the National Petroleum Policy and the National Gas Policy was issued by the Federal Executive Council. So this policy document stated a vision for Nigeria to become a nation where hydrocarbons are used as a fuel for national growth and not simply as a source of income. So this would necessitate moving Nigeria beyond crude oil exports into value-added activities like oil refining and petrochemicals, and leveraging on its untapped gas potential to drive a gas-based industrialization. So we see that demand around us is crumbling in the global market. And so it's now more imperative that structures are put in place to ensure that the value from our oil wealth is translated, that a market basically is built domestically so we can utilize our hydrocarbon resources to drive economic and industrial growth. And the policy document stated several strategic policy objectives. These are outlined on this slide. It's to create a market-driven oil and gas industry, maximize production and processing of hydrocarbons, to move away from oil as a source of income to oil as a source of growth, ensure that there's value addition in country. And of course, this will require incentivizing investment in the midstream and downstream infrastructure that is needed to drive this, to promote market competition, to minimize environmental footprint, and also, given that the direction that the world is going, to manage the balance between the depleting oil resources and renewable energy. So, in the petroleum policy, stated government objective or commitment rather to promote new legislation for the petroleum sector. And the idea is to overhaul the existing framework and modernize the petroleum sector by addressing a number of issues, including sector governance, the institutional framework, the fiscal regime to encourage investors to invest, and the corporate structure of state-owned enterprises, NNPC, transparency issues, accountability, and environmental issues. So the key features of the reform, the legislative reform being driven by government, is to ensure that the institutions are reformed. There's clarity of roles and responsibilities of the various actors that hold regulatory authority. There's clear separation of powers between the various actors in terms of the powers as regards policy setting, powers as regards regulation, and also participating in the commercial activities. There's clear autonomy of the institutions from the minister. So this is regulatory independence, accountability and transparency. As I've said many times, you cannot overemphasize this, ensuring that the regulatory framework is in line with international best practices. Stakeholder engagement is also a key feature, and also emphasis on gas as a fuel in its own right. The current framework, the gas is not really, it's not emphasized at all. And so we could say that in dealing with gas projects, gas regulation is more like trying to see how the framework for oil can be applied to gas. Gas has not been recognized as a fuel in its own right within the regulatory framework. And then, of course, greater focus on development of the midstream and downstream segments, and a clear strategy for long-term sustainable development. So, the Petroleum Industry Bill. As I mentioned, this was introduced in October of 2020, and we've had public hearings, and it's hopefully moving swiftly through the legislative corridors. And so the bill clearly states the objectives, and this is in line with the policy documents that I've earlier discussed. The objective of the bill is to create an effective and efficient governing framework with clear separation of roles, to promote transparency, good governance, and accountability, to create a strong regulatory framework, promote the efficient, effective, and sustainable development of the petroleum industry with emphasis on frontier exploration. This is exploration in areas that have not been significantly explored, and there's prospect for significant resources. And also promoting sustainable development of midstream sector, to foster business growth by creating a business environment that is conducive for petroleum operations, to transform the NNPC into a viable and self-sustaining entity, to create a framework that will support the sustainable prosperity and development of host communities, emphasis on sustainable, and also to establish a progressive fiscal framework that will encourage investment and enhance revenues to government. So it's an all-encompassing bill, seeks to do to address a broad range of issues. It's divided into 5 chapters. I've only highlighted 4 here. The first chapter deals with the governance and institutions. Second chapter deals with administration. Third deals with host community issues. The fourth chapter deals with the fiscal regime. And then we have a 5th chapter that deals with miscellaneous matters like the repeals, transitional provisions, consequential amendments, and interpretation. So, like I had mentioned earlier, it's a broad bill. It's very wide, far-reaching, and it'll be impossible to do justice to this within the time period provided. So I'll focus my discussion on governance and institutions, as well as administration. Today, we'll discuss governance and institutions. Tomorrow, we'll move over to the administration of the sector. Okay, so before moving into that, this is a list of the laws that the Petroleum Industry Bill is seeking to repeal. And what I found interesting, and I'm not sure because I looked all over the bill, I didn't see the Petroleum Act and I didn't see the Oil and Gas Pipelines Act, even though there are other provisions within the bill that suggest that, I mean, as we all know, that these should be repealed, but it was interesting not to see them on this list. Okay. So governance and institutions. Now, the first thing I'd like to talk about, one of the things one of the debates that we've had over this 12-year journey and counting that the PIB has been on is whether the sector requires a single regulator or a dual regulatory model across the value chain. So this is, do we have one regulator that regulates the upstream, the midstream and the downstream segment, or do you have one separate regulator for upstream and another regulator for the midstream and downstream segments? Those that argue for a single regulator say that there are benefits to having a single entity having a view of the entire industry, benefits as regards cost and efficiency as well as synergy. You're able to repool regulatory resources into one body that has this bird's eye view. You ensure sector consistency across the sector in regulatory decisions, and also it will reduce regulatory interfaces and at the end of the day minimize costs to the licensees. Those that argue against the single regulator say that there's a potential that it could be unwieldy and if it's not structured properly or managed competently. And there's also the risk that regulatory functions may not be accorded the required level of importance across the entire chain. Okay. And then those that argue in favor of a separate regulator for the upstream and another for the midstream say that these two segments have different issues. It's best that you have one entity focus on one segment and another focus on the other. So there's targeted focus, and it allows for the full recognition of the diversity of skills required for the different segments. So that's the upside. But those that argue against it say it's expensive. Why do you need to have two agencies that will, almost repeat the same thing? Maybe not necessarily so. They say that there's the risk of information asymmetry in the sense that one regulator may not have the full picture that the other regulator has. It could make coordination difficult, especially in the Nigerian context where you have people government bodies not necessarily coordinating one another. And they also argue that if there's to be a separate regulator, if they even concede that a separate regulator is necessary, it's better combined, the midstream sector and downstream is better combined with the wider energy sector. So you have like an energy regulator and then you now have another regulator for upstream exploration and production. So what does the PIB 2020 do? It adopts the dual regulatory model. The Petroleum Industry Governance Bill that we had previously adopted the single model. The National Petroleum Policy recommended the single model, but the PIB 2020 adopts the dual regulatory model. So here are the key institutions that are being proposed. Of course, we have the minister, and the minister's role is restricted to policy setting and sector supervision. I'll come into that later. And then we have two regulators, the Nigerian Upstream Regulatory Commission, which will regulate upstream petroleum operations, and it's designed to be, well, intended to be designed to be independent. The Midstream and Downstream Petroleum Authority, which, as the name suggests, will be the regulator for the midstream sector. There's a typo in there. And then the Nigerian National Petroleum Company Limited, which is the new entity that will be commercially driven to own, operate, and manage government assets in the sector. So for the upstream regulator, the intent is that it will take over the functions of the relevant departments of the DPR. As we know, the Department of Petroleum Resources, which is a body, or it's part of the Ministry of Petroleum Resources, currently performs functions across the entire chain, upstream, midstream, and downstream. So the relevant departments that focus on, presumably focus on upstream, would flow into the Nigerian Upstream Petroleum Regulatory Commission, and while the other relevant departments will flow into the midstream and downstream authority. The Midstream and Downstream Authority would also take over the functions of the Petroleum Products Pricing Regulatory Agency and the Petroleum Equalization Fund. And of course, the NNPC would flow into the NNPC Limited. So let's look at the minister, powers and functions of the minister. The minister is responsible for policy formulation and administration, and it's also to exercise general sector supervision. It has responsibilities relating to promoting investment promotion and ensuring that there's an enabling environment for investments into the sector. Diplomatic roles, it would represent the FG, the federal government at international organizations, assist with negotiating treaties. It also would have or continue to have the powers to grant and revoke upstream licenses, but the PIB changes the current framework by providing that the power to grant and revoke licenses will be upon recommendation of the commission. And then the minister would have the power to direct the suspension of petroleum operations in any area where the safety of life and property requires. And also the minister would have powers to order cutbacks in crude or condensate production in accordance with international agreements. So this is relevant because every now and again, we read in the news that OPEC has ordered cuts to basically maintain the balance between demand and supply in the global petroleum industry. And the member countries are expected to adhere to these cuts. But what's interesting is that there's no clear framework within which the minister or the government can impose these cuts. And so what this provision does is to provide that power clearly in the legislation that the minister can order cutbacks in crude and condensate production. And then there's a preemption over petroleum and petroleum products in the event of national emergency. And also the minister would have the power to give general policy directives to the commissioner or the authority. This is relevant because even though the idea is to create independent regulatory bodies, it's also important to have that a framework to ensure that these independent bodies work in sync with government policies and reform strategies that are being proposed. But the danger in this is that there's the risk of interference in the regulatory process through this power to give general policy directives. And so people have argued that this power is best restricted by some checks or process requirements, such that the power is not just exercised blindly or widely. The requires the minister to publish such directives in the Gazette, so that at least addresses the issues of transparency, but there needs to be more checks around the exercise of this power. And also, in terms of the minister's power to grant and revoke licenses, there's been debate as to whether this power should vest squarely in the commission and not have to revert back to the minister. And that has been ongoing, but the PIB 2020 has adopted the approach whereby the minister still remains responsible for granting and revoking permits, but this has to be done upon the recommendation of the commission. Okay, so we move on to the commission. This is the Upstream Regulatory Commission. The commission has powers over to exercise technical and commercial regulatory functions over the upstream petroleum sector. And these powers are clearly outlined in the PIB. It includes enforcing all laws with respect to upstream and guidelines that were administered by the DPR, making regulations for upstream operations. And so I didn't see that there was a need to get approval from the minister on the power, when exercising this power to make regulations, which is a good development. It's to ensure compliance with industry standards and practices, administer health and safety and environmental standards, administer and monitor and enforce compliance with license terms and conditions, set and enforce standards for the design, construction, and fabrication of facilities that are used in upstream operations, issue permits and necessary authorizations for technical activities, approve field development plans of operators, ensure payments of royalties, rents, fees, and also monitor the financial viability of licensees. The commission also has functions as regards acreage management. Specifically, it will be empowered to conduct bid rounds, to impose special lease or lease terms and conditions, and this is without recourse to the minister, to administer the license terms and conditions, and like we mentioned, it can renew and suspend licenses with minister's approval, or revoke and suspend licenses, with the minister's approval. And it's also required to keep public registers of leases, licenses, permits, authorizations, including information on beneficial ownership, information regarding awards, renewals, suspensions, assignments, amendments, and revocation of licenses in a public register. And this is very significant because for many of us on this call that are transaction lawyers and have to do a legal due diligence in connection with our clients' transactions, it's getting information regarding the current status of leases and information on the status of licenses. Sometimes it's not very easy to come by, and you cannot even do that without recourse to the person whom you're investigating. And so having this public register, which is required to be on the website and will be available free of charge, will be very helpful for transactions. And then, of course, the commercial regulatory functions. The commission is required or is empowered to approve the commercial terms of field development plans and work programs. It will supervise cost and cost control, develop cost benchmarks, and also implement the cutbacks on crude and condensate production that is ordered by the minister, in most cases in response to the international agreements that we are part of as a nation. Okay, so let's go into the structure, the governance structure of the commission. The commission would have a governing board. So we have a governing board and we now have like what I'll call the top management. The governing board is responsible for policy, administration, and strategic direction and giving guidance to the commission. And it's to be composed of a non-executive chairman, a chief executive of the commission that they've termed commission chief executive, 2 executive commissioners, one that will be in charge of finance and accounts and another in charge of acreage management, and also representatives from the Ministry of Petroleum Resources, the Ministry of Finance, and the authority. And appointment to this board will be by the president with Senate confirmation. This is for the chairman and the commissioners. The representatives from the ministries and the authority do not require this process. And also, the bill provides the grounds for removal. The president can remove, but the president exercises the power of removal and suspension on its own without recourse to Senate, if provided the grounds exist. The top management of the commission is comprised of the chief executive and 6 executive commissioners, each having responsibility over different portfolios that have been outlined in the bill. The chief executive is responsible for the day-to-day running of the commission. The bill goes on to specify the minimum qualification for the commissioners and the chief executive, which is 15 years experience with extensive managerial and technical and professional competence of upstream operations. The term of office is for the commissioner is 5 years and is renewable for another 5 years. And the remuneration of commissioners are to be paid from the funds of the commission. So if we go back to the earlier slides and we talked about the strategic objectives and the key principles that need to be reflected in the new legislation, so independence. Now, the question is, will this current structure, this governance structure for the commission, does that support independence? So for some reason, we have a governing board that is separate from the group of commissioners, and we have commissioners that are not in the governing board. And that is not, I mean, you could correct me if I'm wrong, but I don't think that's not the design that we typically have when we have for the independent regulatory institutions that have been established in these parts. Typically, the commission is comprised of the commissioners, and they are responsible for the strategic direction and all of that. You don't have an entity that sits above them that has other players in it. And this is even more concerning because we have representatives of the Ministry of Petroleum Resources responsible on the board, on the governing board, which will be responsible for policy and administration of the commission and giving strategic guidance to it. So here, there's a clear risk of overlap of roles in the way the governing board is structured. And in terms of qualifying criteria, it specifies 15 years experience, extensive experience in upstream operations. It's argued that perhaps it should be more specific as to the nature of the experience, and perhaps it should be more specific as to the minimum educational requirements that will be required, so that further down the years to come, we don't meet some surprises as to the kinds of appointments that make it to the commission. And suspension and removal, the provisions need to be tighter. I believe it would be preferable if the president acted in consultation, or rather maybe with the approval of the legislature, just as how in the same way the commissioners are appointed. So that gives more credence to the independence. And then we also have some issues around the term of office, 5 years, renewable for further term of 5 years. However, given what we have seen in the regulatory institutions that currently exist, you have a situation where the regulators are all appointed at the same time. They all go through the learning curve at the same time, and they all leave office at the same time. And then we now have a gap before another set of commissioners are appointed. It would be preferable if the bill provided for staggered appointments, such that the initial set of commissioners have different terms applied to them, so that at every given time, there's a commissioner within the setup that is not learning the curve with the rest of them. And there are many benefits to having staggered appointments. It preserves institutional memory. It promotes fresh perspectives and diversity within the regulator. It also makes corruption difficult, because if you're coming in newly and you see like a set of people that are already there, you don't quite know how they would react to certain things. So in theory, it will make corruption difficult. And most importantly, it makes it difficult for a single appointer to dominate or influence the composition of the commission. So if, for instance, in one presidential administration, they appoint all the, is responsible for appointing all the commissioner, there's a single appointer, but where you have staggered appointments, you would have commissioners appointed by one administration rather, together with commissioners appointed by another administration, and that way that fosters some higher level of independence. There was also a question about who determines their remuneration. This is not mentioned at all in the act. In the bill, I did not say anything about who determines the remuneration of the commissioners. Ideally, there should be specific provisions saying that they determine their own remuneration, because financial independence is also critical to ensuring regulatory independence. So that is not there. And interestingly, and I believe maybe it's a drafting error, while there are provisions governing how members of the governing board will be appointed, what we don't exactly see, I didn't exactly see anything about the other commissioners that will not be on the governing board. I believe it's assumed that it will follow the same process, but that is not specifically stated. And those are the loopholes that could be exploited if the bill is passed in this form. Okay, so employees, like I mentioned, for the commission, employees in the relevant divisions of DPR will transition to the commission, and to transition on terms that are not less favorable than their current benefits. The bill allows the board to determine the number of employees that the commission requires, as well as the terms and conditions of service. And also in terms of remuneration, that's also determined by the governing board, but this must be done in consultation with the National Salaries and Wages Commission, having regard to the nature of the work to be performed, the need for self-sufficiency of the commission, financial self-sufficiency of the commission, and also having regard to the remuneration paid to persons that have equivalent responsibilities and expertise within the private sector. So the idea behind this is to be able to attract skill into the commission. But the issue though is that when you have this automatic transition of employees in the relevant departments in DPL, automatically transitioning to the commission, will we not have a case of old wine in new wine skins? How does this automatically transform into a more effective institution by just changing the name? So it's been argued that there are serious pitfalls that will come with moving employees en masse into the new commission. And how do you, the new corporate culture versus what's the status quo? How do you change that? And so there should be a clear, I think more needs to be done as regards how the initial staffing of the commission will be executed. Interestingly, the bill allows the minister to draw on expertise from other agencies within the sector. For instance, you can draw from people in the DPR, in NNPC that have the relevant expertise to come into the commission, or other agencies. So that's a positive. But I think more focus needs to be made as to how you get the right crop of people to come into the commission at the initial stages and drive the commission in the way, with the manner of effectiveness that is needed to implement the sector reforms. Okay, so funding. Another critical part of ensuring regulatory independence is also financial independence. So how will the commission be funded? The bill provides that it will be from money appropriated to it by the National Assembly, money derived from revenue collection in accordance with government policy. That's a little loose. And then fees charged for services that are rendered to licensees and lessees and permit holders for using the commission's facilities, income derived from publication and sale of data, grants, gifts, etc. So the question that arises here is whether these funding provisions will support the independence of the regulator. Ideally, most of the funding of the regulator should come from basically a levy on the industry, because we don't want a situation where you are dependent on funding from budgetary allocations, and in that way that affects the independence that you're able to exercise. But if the funding is derived from levies imposed on the industry, it creates a higher level of independence. So that's one issue from the funding provisions here. Okay, so we had mentioned that part of the objectives that petroleum policy is seeking to achieve is promote exploration in frontier basins. And to achieve this, the bill provides for, the bill first of all gives the commission the responsibility of promoting exploration in frontier basins. And also, for this purpose, the Commission can engage competent persons to carry out these exploration activities on a service fee basis. And to fund this, a Frontier Exploration Fund is to be established and managed by the Commission. The source of this fund will be 10% of the rent on prospecting licensees and lessees, and we'll have regulations that will prescribe how this fund will be managed. And so while this is a laudable initiative, the concerns about whether this role is properly situated with the Commission, given that the Commission is a regulator and not basically in in the business of operating. So that's a key concern, and it could result in overlaps, or rather, will result in overlaps. Okay. So that's that with upstream, the entity focused on upstream regulation. So now let's move on to the authority, which will be focused on midstream and downstream regulation. So the provisions regarding the functions and powers of the authority are a little bit all over the place, and a lot of work will need to be done to streamline those provisions. And so outlined here are the functions and powers that I thought were more streamlined. So the role of the authority rather is to ensure the efficient and safe and sustainable development of the midstream and downstream operations, is to exercise technical and commercial regulation of midstream and downstream petroleum operations, enforce laws and regulations in this regard. It will administer licenses and permits for midstream and downstream operations. And in this regard, there's no recourse to, it's not the minister that issues these licenses, it's the authority. And it has the powers to make and enforce regulations, powers with respect to pricing and tariff regulation, competition regulation, third-party access rule. Interestingly, it's also empowered to determine the domestic gas demand requirement and also the domestic crude oil supply requirement are supplied, and ensure that these domestic demands are met. So here, there's the risk of an overlap into the functions of the upstream regulator, but it remains to be seen how this will be applied. It's also to ensure implementation of the environmental laws and policies, and define and enforce standards for the design, construction, operation, and maintenance of downstream and midstream facilities. So we have similar issues with the governance structure of the authority. It's a similar structure, a governing board that has a non-executive chairman, the chief executive of the commission, two executive directors, one responsible for finance and accounts, another for distribution and transportation, two other non-executive members, and then representatives from the Ministry of Petroleum Resources and Finance, and a representative from the Commission. Same manner of appointment. There's a top management that will comprise of the chief executive and 7 executive directors. Directors will have their dedicated areas of responsibility. While we have provisions that state how members of the board will be appointed, we don't see the appointment for the other commissioners appears to be missing. Similar qualification requirements, similar term of office, similar provisions as regards remuneration, and similar concerns as to regards whether the structure will support independence of the commission. Employees, it's also similar concerns as well. So employees of relevant divisions in DPR, the PPRA, and the PEF, PEF fund will transition to the authority on terms of service that are no less favorable than what they currently enjoy. So we have the issues as to whether will this not be a case of old wine in new wine skins. Funding is also almost similar issue, similar funding structure, except that there's provision for a percentage of a levy that will be prescribed on wholesale price of petroleum products sold in the country that will comprise part of the funding sources for the authority. So the regulation is not, maybe it is to be specified, but generally concerns about whether the funding provisions will support the independence of the authority that are similar to the commission also apply here. Okay, so that's that with the structure of the upstream petroleum regulator and the downstream and midstream regulator. I had mentioned earlier that part of the key imperatives for the sector legislation is one that enables stakeholder engagement. And we see that in the petroleum industry bill, there are extensive provisions regarding how stakeholder consultation when issuing or amending regulation. Basically, stakeholder consultation increases the level of transparency and it helps to improve regulatory quality because the regulator sees different perspectives as to how the what is being proposed could impact the industry, and also just fresh perspectives on the real impact of any proposed regulatory framework. And so we see that the PIB has very detailed provisions on this. It requires that for regulations to be issued, stakeholder consultation is mandatory. However, for policy formulation, it's silent on this, so it appears to be left to the minister to determine whether or not stakeholder engagement will be followed if new policy is to be issued. And so for the purposes of regulations, the stakeholders are to include licensees, lessees, permit holders that may be impacted, and other persons interested in the subject matter. There are detailed provisions as to how public notices must be given in the national dailies, on the website of the commission, and but there's also provision for the requirements of stakeholder consultation to be bypassed if the national interest required or if the exigency of the situation required. But this power to bypass stakeholder consultation is limited because any such legislation, any such regulation that emerges would only be valid for 1 year unless it is like confirmed by subsequent stakeholder consultation. So those very laudable provisions in the petroleum industry bill, but it will be It will be great to see that a similar structure is also included for the exercise of the policy formulation powers by the minister. Okay, the petroleum industry bill also seeks to establish a midstream infrastructure fund. So in the earlier slides, I had talked about how there's this emphasis on establishing the midstream and downstream segments as a segment in their own right, how the policy is seeking to promote development of infrastructure in this segment, how this segment is crucial to our gas-based industrialization plans projections. And so the PIB now goes further to establish a fund for this purpose. And this fund is to replace the petroleum equalization fund that currently exists. The petroleum equalization fund is a fund that is put in place um, to basically um, cushion the impact on petroleum marketers of supplying petroleum products at uniform prices across the country. And so with the recent deregulation of the downstream product sector, it's the continued relevance of this fund is actually in question. And so it's interesting to see that the bill sort of moves further to replace this fund with a fund that will drive investments in the sector that is critical to ensure our economic growth. And so the purpose of the Midstream Infrastructure Fund will be to fund the FGN's equity investment in midstream gas infrastructure that are part funded with private investment and are aimed at increasing domestic consumption of gas. So it would appear that the purpose of this fund is not for government to invest. These are not projects that government will have the driving seats in. It's projects that that the private sector is most likely driving, and government is providing some equity to fund that project. So the source of the fund will be 1% of wholesale prices of petroleum products and natural gas sold in Nigeria. So this will be levied, and that goes into the fund. Donations and grants from multilateral agencies, etc., and also the amounts remaining in the petroleum industry, the Petroleum Equalization Fund, after all its obligations have been discharged, will be transferred into this Midstream Infrastructure Fund. The Midstream Infrastructure Fund will have a governing council that will supervise and make investment decisions. The governing council will comprise of a chairman, representatives from the central bank, and the minister of finance. Sorry, the minister will be the chairman, and there'll be representatives from the CBN and the Ministry of Finance, and also three representatives from the authority, which will be the chief executive, the executive director that is in charge of the Midstream Gas Infrastructure Fund, as well as the legal advisor. And it also provides for the appointment of two independent members, which will be appointed by the Minister of Finance. It requires that a transaction advisor be appointed where necessary to provide transaction advisory services in connection with investments that it makes. And such transaction advisor will be selected through a competitive and transparent criteria. So this is all good, this initiative, but the slight concern here is the entity that is driving this midstream infrastructure fund. We have three representatives of the regulator in a fund that will provide, driving a fund that will invest in the sector. So basically an overlap between regulation and commercial operations. How do you regulate an entity that you are investing in? So those are questions that I trust will be resolved as the bill progresses towards being passed. Okay, so the next institution, or the last, is the Nigerian National Petroleum Company Limited. So the policy goal is to design a national oil company with efficient and effective structure that will withstand the challenges in the global energy environment, that will drive the energy transition, that will withstand political interference, and also drive the national economic aspirations, and most importantly, that can function independently without recourse to the Treasury. So it can independently access capital for its operations without recourse to the Treasury. So the bill seeks to establish, well, not establish, provides that within 6 months of coming into force of the bill, the NNPC Limited will be incorporated. And the mandate will be to carry out operations on a commercial basis, assume the working interest of NNPC, the existing NNPC, in its current joint ventures, and also maintain the role of NNPC for companies that elect not to convert their licenses and leases. I'll have to come back to this, shed more light on this tomorrow when we discuss administration. The NNPC Limited would also be vested with rights to natural gas under PSCs, that's production sharing contracts that have been entered before the PIB comes into force. And it would lift and sell royalty oil and profit oil for commercial fees at the request of the Commission, and also promote the use of domestic use of natural gas through the development of large-scale gas utilization industries, and is also mandated to develop renewable energy sources as we transition towards renewable energy. The bill provides that NNPC Limited and its joint venture partner may voluntarily structure their venture into an incorporated venture. So this is different from what we had in the past. Now there's a voluntary, now entities can move into the IJV structure on a voluntary basis. It's no longer, it's not, the proposal is not to make it mandatory. The proposal going forward now is to have it, to make it voluntary. Okay, so I mentioned earlier that the NNPC Limited is to be incorporated within 6 months of commencement of the Act. At incorporation, the shares will be held on behalf of the federal, by the Ministry of Finance Incorporated on behalf of the federal government, and initial funding will be derived from cash payments made by the federal government for subscription to its shares. So that's specified in legislation that the federal government will pay cash for the shares that it subscribes to. The Ministry of Finance Incorporated may increase the equity capital if at any time if it so requires. The bill specifies that the shares held by government will be non-transferable. And so they'll be non-transferable. So if there are going to be any transferable shares at all, perhaps it will be from increases in equity capital and if private investors are invited to participate. Notwithstanding, it also provides that any sale of shares shall be at fair market value and subject to open, transparent, and competitive bidding processes. So you have to competitively bid if you are to get shares in the, if you're to buy off shares or if you are to be involved in the sale or transfer of shares in the NNPC. And most importantly, it provides that the NNPC and subsidiaries are to conduct their activities on a commercial basis without recourse to government funds. And this is supposed to be specified in the memorandum and articles of association of this entity. So what's not very clear in the provisions as regards NNPC and shareholding within NNPC is whether to what extent can the private sector invest in it? Are there plans to list the NNPC Limited at some point in the future? There's no clear direction as to whether there will be privatization. It would always be a government-owned entity. And so that needs to be very clear. It seems suggested, but it's not very clear. And the pathway to achieving that privatization as well needs to be clarified. So as regards transfer of assets and employees, the Minister of Finance is to determine the assets and liabilities that will be transferred to NNPC Limited or its subsidiaries, and that will be done within 24 months of the coming to force of the PIB. Any asset or liability that is not transferred will remain with NNPC, the corporation, until it's extinguished or transferred to the FGN. And after that, NNPC, the corporation, will cease to exist. And then NNPC, the corporation, will be, the NNPC Limited, rather, will be appointed the agent of NNPC, the old NNPC, to manage its winding down process. The cost of winding down will be borne by the federal government. And after that, NNPC will cease to exist. Employees of NNPC will be deemed to be employees of NNPC Limited automatically upon its incorporation. So the same queries that we have as regards transfer of employees for the authority and the commission also apply here. Will the wholesale transition of employees from the current existing NNPC to NNPC Limited drive the policy aspirations for an efficient and effective and commercially oriented NOC? That's a question that will need to be looked into and resolved. So the board composition for NNPC Limited, the bill prescribes that for as long as the entity is wholly government owned, the president will appoint members of the board, and it will comprise of a non-executive chairman, a CFO, and the CEO and chief financial officer of NNPC Limited, as well as representatives from the Ministry of Petroleum Resources, the Ministry of Finance, and 2 non-executive directors. Whenever it's not wholly owned by the federal government, then the appointments, the board composition will be determined by the shareholders in accordance with the Companies and Allied Matters Act. the concern about this initial setup, the initial board composition, is that it seems to be too government-centric. We see that as a CFO, the CEO and the CFO, the minimum criteria is specified, which is the same sort of minimum criteria for the authority and the commission. But we believe that for an entity that is supposed to drive, manage federal government assets in the petroleum sector and transition to one that is commercially oriented, there should be more specificity as to the nature, the type of qualifications that the CEO and CFO should possess. And there should also be provision for independent directors as well to ensure proper corporate governance. And what's interesting is that when you look through the bill and you see the responsibility of the board that is outlined, there's a very strong emphasis on maintaining ethical standards, transparency, and just establishing performance indicators and ensuring that the NNPC is run in a way that is commercially oriented. So I've listed in this slide the provisions that I thought were interesting. Is to apply highest ethical standards. The board is to apply highest ethical standards in performing its duties. It's required to make decisions guided by commercial and technical considerations, determine key performance indicators on an annual basis, set performance objectives, monitor the effectiveness of its governance practices, oversee a succession plan, monitor and address potential conflicts of interest, ensure integrity of its accounting and financial reporting system, and ensure that an appropriate system of control is in place for risk management, financial and operational control. So I believe that these are all very interesting provisions, and there's the requirement that these provisions be mirrored in the Memorandum and Articles of Association of NNPC Limited. And there are also provisions regarding corporate governance. Like I mentioned, board members are to observe the highest standards of corporate governance. And there's provision for shareholders that hold up to 10% voting interest to request the board to provide a written explanation of any act or decisions taken by the commission. So that ensures transparency and accountability. And then, of course, requirements for annual audits by independent auditors as well. Okay. So, come to the end of my slides. And so to conclude, we'll go back to the petroleum policy and the key features for the legislative framework. And so the question now is, if you look at the governance framework in the petroleum industry bill, to what extent can it deliver on all of these fronts? And I think as you go through the bill, which I hope you will, just look at these provisions and ask these questions and try to assess to what extent we can achieve our policy aspirations as provided in the current draft of the bill. The bill is evolving, so that's a caveat that I should have given at the beginning. So you may very well find that none of these provisions, or maybe a significant chunk, may not be eventually passed. But it's interesting. It's important to understand the context within which what we'll eventually have came into being. Okay, so thank you.
Hi, Jumoke. Thank you. Thank you. Okay, so we're just going to jump into the questions before we have DOA come in and take one for a few, take one. Okay, so we'll just jump into the questions now. Okay, sorry. Is DOA, I'm thinking we should have DOA come on now. If he's ready, then we can take the questions together. DOA, are you ready? Or we should take
Yeah, that's fine. I'm happy to sort of jump in.
Okay, please jump in now so we can just take the question. So both of you can take the questions together.
Okay, 1 second, please. Just trying to switch on my video. So good afternoon, everybody, and thank you, Jumoke, for that excellent presentation. Thank you to Inta for the introduction. I should say Jumoke has said a lot, has sort of covered all the bases in relation to the governance of the oil and gas industry under the Petroleum Industry Bill. I thought it was important actually to maybe highlight a few points drawn from her presentation. The first thing was to emphasize why the separation of powers is important. So one of the objectives of the Petroleum Industry Bill and the Petroleum Industry Policy is to separate the roles played by the government in the petroleum industry. So what we have now is we have the government playing a role as a policy maker. We have the government playing a role as a regulator in the form of DPR. And we also have the government playing a commercial role. Now, the role of policymaker is played by the minister. The role of policymaker is played by the minister. That same minister sits as the ultimate person to whom the DPR reports to. So the minister is policymaker, is also regulator. In addition, that same minister sits on the board of the NNPC at the moment. So the minister's role kind of cuts across the sector into the policy, into the regulatory, and into the commercial space. We also see many announcements being made by the NNPC that are really areas of policy and perhaps also areas of regulation. So let me give an example. Last month, actually earlier this month, the NNPC made an announcement that there will be no changes in the price of PMS. That is a regulatory issue, and that is an issue that should be decided by the regulator. And indeed, the regulator made one or two pronouncements on that issue, but had to wind back that pronouncement. And what that tells you is that the commercial player in the sector, which should be regulated by, for example, PPPRA, the Petroleum Products Pricing Regulatory Authority. Well, that institution, the NNPC, seems to have much more power and indeed more resources than perhaps the PPPRA and the DPR. And the ability of the regulatory institutions to actually regulate that institution is limited. And so the principal driver of the bill is to say, let us identify what the different government roles are and to allocate those roles to different organizations and institutions. And so, and also, as it were, attach KPIs to the different organizations that are carrying out the roles, so that we can see if you have a commercial function, your function is related to to the commercial areas. You are not required to dabble into the policy aspects or into the regulatory aspects as well. And it's important so that we can assess at the end of the day, did this person or did this organization carry out the functions in the way in which they were meant to be carried out or not? I think that I thought that it was important to emphasize that. Jumoke also talked about the issue about single or dual regulator. And this may seem to be an arcane issue, i.e. something that only people in the petroleum industry are concerned about. But it really speaks to the consistency of government. If the government, this same government, under this same president, issued a policy document in 2017 that says we should have a single regulator that cuts across the sector. The same government then issues a draft bill in 2020, I believe it was, yes, in 2020, saying that we should have multiple dual regulators. From an investor perspective, you ask yourself, what is going on in on the government side? Why is there no consistency? At the very least, what you would expect is that the government comes out with an amendment to its policy position rather than just trying to change it through legislation. So those were two issues that I thought it was important. And I think the last one would be around the issue around NNPC and how that evolves. It's not enough to turn NNPC into a limited liability company. The obligations, the liabilities, the restrictions that are imposed on a limited liability company should also apply to NNPC. I think that is really important. What we've seen, for example, even with subsidiaries of NNPC that are registered as limited liability companies, they have not operated with the same corporate governance principles that work for other limited liability companies. For a very long time, they were not filing their returns as they should. For the very long time, board appointments were not being made by the shareholders of the company in accordance with the Companies and Allied Matters Act. And there is no point in creating a limited liability company that does not follow the principles of a CAMA. I think that's a really important point to emphasize. And one of the things that Jumoke said further to that is it's not just about corporatization. It is also about having other influences within the national oil company. So if one of the things that Nigeria says often is that we want to have a national oil company like Statoil, which has changed to Equinor now, like Petrobras, but all those examples are national oil companies that a significant chunk of their shareholding is held by the private sector. And bringing in the private sector into the national oil company, even if it is at a minority level, helps to influence the approach to governance. And decisions will not just be taken right at the presidential level, but the shareholders will be a part of that decision. And I think that's the broad context, and those are the broad things I thought I should add to Jumoke's excellently delivered presentation. Thank you all for giving me some time to speak to this.
Okay, thank you, Dre and Jumoke. I guess we're going to quickly go into questions now. So let's just get on with it. Okay, like I said in all our other presentations, the slides will be available to all participants at the end of the training session. So, so I'm going to just keep most of the questions with those questions now. Okay, so we'll just start with, so Adeboyega is asking, are the reasons PNB refused assent earlier already remedied in the bill now before the National Assembly? How has the interest of the oil producing communities been properly taken care of now to avoid further agitations in the Niger Delta?
Okay. So for the reasons why assent was declined under the PIGB. I know there were reports citing that there were issues around funding of the commission. There were reports about the power of the minister being whittled and minister, and they didn't, I mean, that wasn't very favorable. So for me, it's not really clear what the true reasons are or the documented reasons are. But in any event, the bill was taken back and represented. The structure of the governance institution has changed. Under the PIGB, we had a single regulator for the entire value chain. Now it's a dual regulator. The minister clearly has the power to grant grant licenses and leases. The compromise is now ensuring that that power is exercised in consultation with the commission. So yes, so I believe that those have been taken care of. On host communities, the bill provides for oil and gas operators to establish a trust for the translation of benefits to host communities, and that trust is to be funded by 2% of their operating net revenues. So that's in a nutshell what this is about host communities. And there's contention about whether or not that's sufficient or too much.
Okay, so Henry is asking, does this bill address host community interests? I think you've answered that already. Will the UK Supreme Court decision in Okwabi versus RDS have any impact on this bill, with particular reference to disputes that may arise from its implementation?
Okay, well, I don't know in what context the decision could have an impact on the bill. I know that and in terms of the provisions and administration, the bill provides for a new types of leases and licenses to be issued, and the fiscal regime is expected to be better attached to those licenses than what we currently have, and operators are at liberty to convert their licenses, the existing licenses, to those ones. But part of the condition is also to drop any claims that you have against the federal government. So that's where there will be an impact on disputes. So I hope, I don't know if I've addressed your question, because I'm not quite sure in what context this will have an impact.
Okay, so Sumbo is asking, do you think the PIB provides truly independent regulators in upstream, midstream, and downstream petroleum industry? Do you think regulatory capture will occur consistently under the proposed PIB regime?
I don't think it provides truly independent regulators for the reasons that I stated during the presentation, reasons around how basically how the governance structure of these regulators, how they are funded, how they are appointed, and the roles they play. So a lot of work will still need to be done to ensure that these entities are truly independent.
Okay, so another question is, should the regulation of the petroleum industry be subjected to political control by the National Assembly as proposed in the PIGB? What negative impact could this have on efficiency and transparency?
Okay. So I'm not sure the PIGB proposed for the regulation to be subject to political control. What we don't want is political control of over the regulation of the sector, which is why we're advocating for independent regulation. So definitely no to having political control, and yes to independent regulation. And yes, political control will have negative impacts on efficiency and transparency. So that's, yeah. So that's a no.
Okay, so Christopher is asking, how are emerging energy sources and climate care built into the bill?
The bill doesn't specifically address emerging energy sources. It's focused on the petroleum industry, but there's a wider policy objective policy aspiration to basically adopt more renewable energy within the energy mix. And I think as part of the functions of the NNPC Limited, there is the objective that the NNPC Limited will drive the corporation through the energy transition phase. So it's expected, I believe, to also pursue projects in those areas, just like we see the IOCs are currently doing.
Okay, so Ayomide is asking, please, did you say the president has full powers without recourse to the Senate to suspend and remove? That's one. And why though? Is there a known reasoning stroke interpretation behind the provision?
Yes, I did say the power of suspension and removal is exercised by the president, provided the grounds for suspension and removal exist. So the grounds have to exist, but there is no recourse to the Senate. And if you compare that with the Electricity Power Sector Reform Act that establishes the NERC, removal of commissioners, the president has to have recourse to the Senate for that removal to be implemented.
Okay, so Mohammed is saying that he foresees a possible conflict with the Constitution on spending revenue collectibles by the Commission without legislative appropriation. She's asking for your views.
I'm not quite sure where the conflict will be, because in this case, these are not like, this is not revenue from the sale of its resources. The revenue that is being provided for is revenue from basically providing administrative services to the leases and licensees, use of facilities, sale of data, to basically perform its legislative functions. And where there's clear provision that the funds of the commission will comprise of this, I don't see the possible conflict.
Okay, Dure, I think
then again, I'm not sure if I've answered that question correctly. So.
Dure, would you care to jump in here? And I have a question to after this one. So do you care to jump in and add to what Jumoke has said?
Sorry, could you go over the question again?
So just bear with me. So the question was, so Mohammed says he foresees a possible conflict with the Constitution on spending revenue collectible by the Commission without legislative appropriations. He's not asking for our views on that.
Yeah, look, I agree with you. Okay, I think that, I mean, it certainly depends on what you're collecting revenue for. Certainly anything that has to do with the licenses or the leases, i.e. a signature bonus or anything like that. If you use that revenue, you might have constitutional issues. But revenue in relation to potentially fines, penalties, possibly to do with the acquisition of data, I wouldn't be concerned that the utilization of that revenue, or even a levy, as Jumoke had suggested, I would not be concerned that the utilization of that revenue will breach constitutional matters.
Okay, Dure, you should take this question. It asks, does the percentage allotted to host communities do away completely with the corporate responsibilities of the IOCs to host communities where they operate?
No, it does not.
Okay, talking about this control shielded from political interference. No, this wasn't a question, this is just a thought. Christiana is asking, the president has absolute powers of removal without recourse to the Senate. The president is also the Minister of Petroleum. This power is too concentrated. There should be separation of powers in this regard, don't you think? I think that was just a thought. Do any of you care to add to that?
The president doesn't have to be the minister of petroleum. This president has chosen to be. Some of the presidents in the past have also chosen to be, but there's nothing that requires the president to be the minister of petroleum. And yes, that would be my view.
Okay, Jerry, I actually think I would have wanted your input on the issue of, so the question of how are emerging energy sources and climate care built into the bill?
100% I agree with you, Moke. It's not in the bill. I think, it's really a function of how we've focused our economy and and our governance. Petroleum and energy, the wider energy world is separated in governance, and people don't think about them together. But the way the world is moving, it is quite important that we do so. And even if it's not in the bill, there should be some measure, a policy document, something that addresses a holistic look at the energy industry, with petroleum included, as well as renewable energy, etc. But right now, we don't have that holistic view. And I think it's going to be a problem for the future.
Yeah, because I'm just thinking as a layman, in most very civilized countries where everyone is, we're moving away from fuel, and going into, so a friend of mine would tell you that they're not going to buy a certain car because in the UK right now, because by 2030, so where are we in terms of, if this is where, a sophisticated country is, we're just still talking about honestly, from a layman perspective, I really,
look,
I don't know.
It's not just a layman perspective. I think it's a challenge that everybody's thinking about. If you think, what's the potential impact on us? Primarily oil has been driven towards the export markets, which means that it goes to countries like the US, not so much in the US now, but countries around the world. Well, if they stop using fossil fuel like crude oil for their energy demands, what does that mean for us? It means, one, we have to find other markets, and if other markets are sort of think around the same way, it may be a challenge. And the two is, we've got to find a way to use that oil that we are not able to export as much of again. And that is a large way which we should be thinking about it. Obviously, I think in the next 20 years, Nigeria will still be primarily using fossil fuel for driving vehicles, possibly for our power, although, we will move progressively towards renewables. But the immediate impact for us from a policy perspective has to be, when there's no longer a market for our oil, what should we be doing with it? And that's a really major impact that we need to plan and think about.
Okay, I guess Nigeria will always play catch up when the time is right, but it's time to buy Tesla shares. Because that's where the world is going to. Okay, I think there was a conversation about employees in the oil sector. So there was a comment on it. I think it came from the chat section to the Q&A section. So I'll just read the comment someone made, Innocent made. He said, I think the automatic transitioning of employees is vital for industry stability. One can only imagine the magnitude of strike by union if one was to get rid of the old worker. Just my thought. I was hoping that either Jumoke or, of course, Jumoke, I'd like to hear your views on this subject, because I think it started from the chat section and came onto.
It's an interesting observation. It's actually one that I struggled with before I made the comments that I made, that how do you just throw people out on the streets? But I think there are creative ways that one can go about it. The civil services is very large, and skills are needed in different skills are needed in the different agencies and institutions. And so the PIB already, gives the minister the latitude to source for the required skills within the framework of the petroleum industry bodies to go into the relevant commission. So it doesn't have to be like a wholesale transfer. And you can also transfer, they're fond of transferring people out to, you're not performing, they would send it to, send it to the ministry that is not making money. So, but yeah, that's a limited solution, I agree. And it's a perfectly understandable concern as to what will happen to people that don't survive that transition. Definitely there'll be strikes, and it's something that will need to be managed carefully. But the goal really is sustainable development for everybody. So balancing that will be interesting.
Do you care to add to this subject?
No, I mean, sorry, I think Jumoke has said it all, really. I agree with that 100%.
Okay, so another question is, Lucky's asking, does the new bill take into consideration the problem associated with the commissioning of oil platform?
Yes, it does. And I think Jumoke is going to deal with that tomorrow under the administration aspects of the bill.
Okay, so from Florence, why is it that in removing a director, the National Assembly are not involved except the president, while in appointing one, the National Assembly is involved? So, question?
I think we addressed that earlier. Somebody asked a similar question about that. I don't know why it's drafted that way. I'll prefer it not to be drafted that way. So that's a question for the draftsmen as to why they chose that approach.
Okay, so I guess that's it for all the questions on this side. I want to thank, so I don't know if we had a proper introduction of, both of you. DOA is my friend. I've known him since I was in law school. so he's the managing partner of Introductory and Adifty. And so Jumoke is a partner in, sorry, let me just get that out. So just before I hand over to the chairman of the ICLE board, the governing board of the ICLE. So I just wanted to say thank you. Thank you to Jumoke and thank you to Dire. So Tobina, over to you to give your opening remarks, which will now be a closing remark.
Thank you very much, Nta. So I've thoroughly enjoyed this session. I was wondering how the session was going to play out. It's always interesting to listen to something that is largely futuristic, but in many ways uncertain. I mean, many years ago, when foreigners especially came to invest in Nigeria, not many years, 2-3 years ago, or even 4 years ago, they will always ask about an opinion on the PIB, and you spend a lot of time trying to explain where we are, what the bill generally portends. But these days, I think they've even gotten tired. I mean, something that's been walking through the legislative houses since 2008. Anybody will feel irritated. But it speaks to the paradox of our country, that the paradox that is Nigeria, that the most important bill, if you like, has been making its way and been subject of all sorts of controversy. But I think it's something that I mean, the presentation by Jumoke and Dio is very exciting in the sense that it actually sort of also, whilst discussing the bill, critiques the current position of things as far as regulations in the oil industry is concerned, and actually opens our eyes to where we are going to get to inevitably. And I like the conversation around the Minister of Petroleum and all of that. Again, probably the most important ministry in Nigeria haven't had a minister, I think, from Obasanjo's time, and it becomes a fad where the president wants to be the all-important man that controls the money. But I would say a very special thank you to Jumoke Fajemiroku for a brilliant presentation. to Dioya Adefolu for coming in, and on short notice, but also doing a brilliant job of the contributions that he's made. I'm very, very grateful, and we are all grateful to the entire faculty, the Energy Law and the Policy faculty. They've spent a lot of time putting this together. And I thank the participants, everyone who has come and participated in today's session. I hope that you all show up tomorrow. And we keep saying that we should encourage other colleagues and friends to participate in these trainings. I mean, so people talk about specialization and all of that. And I think beyond specialization, if people have the time, expanding the frontiers of knowledge is something that we're about. Picking up stuff that, because even if it's not your area of practice, and perhaps someone else practices in that field, it's always good for a lawyer, I can tell you for free, to have some knowledge about what is happening in an area, and you never know where you pick up your interest from. So thank you very much, and I hope to see you all tomorrow. Jumoke, I know tomorrow's session will be more interesting than today's own, and Dioya, hopefully we'll see you. I saw some other panelists earlier on, and I hope we'll have a full house tomorrow. God bless you all. See you tomorrow. Bye.
Thank you. Bye.
Bye.
Thank you. Bye.